So there's typically a risk provision, and that happens or just kind of outlines that when at the moment that completion is the completion of the contract is executed, which is typically on the completion date. As of 12/01 of the following date, the risk will transfer. The risk or liability for that property will typically transfer from the seller, the vendor, to the buyer, and this is kind of significant because let's say at 12/04 of the following the completion date, I don't know, the building starts leaking. Yeah, the building starts leaking, and so all those the risk of the cost or the cost of remediation or the cost to fix all that damage would typically be borne by the purchaser because it's risk has passed as of that date, and that's kind of significant because you kind of want to set up ensure that you have home insurance so to protect your liability or protect your costs as a buyer once you've received the title of the house, or rather once liability or risk of that property has passed to you.
What if there's a leak on the property that should have been noted in the inspection but maybe wasn't? What does the risk or the liability fall on myself, the purchaser, or does it go to the seller?
That's a whole different kind of
Yeah, I mean that's a loaded question. I think I think it really depends on when that leak occurred, whether there's knowledge of it, why that leak occurred. Sometimes if you're in a condo building, it could be because it could be something that happened, a pipe in between the units that caused leak versus inside the unit. So all those factors come into play. So yeah, I think that's a bit. We would probably need to examine or hear about each individual circumstances before we probably be able to properly answer that.
And that's why you come to a law firm.
Yeah, exactly.
All right. And just looking at here, this contract, what do they mean necessarily, like under the plural section? What is that about? I don't even know what plural is.
In this contract, any reference to.
Oh, so that just means that if there's an improper reference, whether it is singular versus plural or masculine versus feminine, it doesn't really change the terms of the contract just because it's incorrect. Okay, so I will talk about this one portion, 21 restrictions on assignment of contract. So this was put in not too recently due to the fact that a lot of people were flipping properties out in BC. At one point people were flipping, and at another point people were shadow flipping, and then so eventually the BC government came and said, well, we should probably stop that because effectively the purchaser who then sells it to somebody who then assigns it was unhappy because they were feeling that they didn't actually get the full purchase price that they could, because the seller who then flips it would assign it for a profit. And so the BC government came up with this restriction on assignments of contracts that really prohibits the assignment without the written consent of the seller, and then also the seller would be entitled to a profit emanating from the assignment, just because it was a situation where I think it was getting out of control, and so that's why there is this clause that's put in now.
So do you guys have anything further to add on this episode?
No, I think that pretty much sums it up. That's it.
No, thanks for moderating for us.
Yeah. Thank you guys for joining in to our episode on private contracts. Be sure to tune in next time. But if you have any further questions, you can always call us or email us, and we'd be happy to answer any further questions. Thank you.
Thanks.
Thank you.